If you had to compare the era in which we're living right now with a few other different times legally that we can kind of compare to throughout our talk, what would some of those different times be, and how do you think that they have more of a direct correlation with the events that we're experiencing today?
Well, um, it's to me and other constitutional scholars and other legal scholars, it's rather simple, and it really doesn't matter. Again, what your political views are. Um, there has been very few times in our nation's history that experts almost unanimously agree constitute what we call a constitutional crisis. And what that means is that the political and or um, uh, you know forces that are happening in the country, the conflagration of different things happening, combine together to seriously threaten our ideas as to what the foundations of our legal system are. And to give you an example, the first unanimous opinion of what is a constitutional crisis is, of course, the Civil War. I mean, that literally was the nation coming apart because there were unanswered questions as to what the framers really intended for our country. And so people don't understand that the Constitution, as it was written, was defective from the start, and it preordained this constitutional crisis, and it basically had to do with the southern states would not ratify the Constitution unless there was a Bill of Rights. Now, today we think of the Bill of Rights as probably the most important part of the Constitution. It's the one everybody knows: the First
Right.
Amendment, the Second Amendment, all that stuff. It basically enumerates individual liberties. And I'm not saying that the Bill of Rights is a bad thing, because it's not. But the reason why the states, the southern states, insisted on writing them down or enumerating this Bill of Rights before they ratified, because Jefferson didn't want to do that. He said, I didn't want to write them down because that to me is almost confining them to just those rights. He wanted to almost assume that those rights were valid. And the southern state says, no, absolutely not. We want it enumerated. And the reason for that is that the structure of the country in the beginning was not necessarily a republic. It was a republic on paper, but it was a confederacy. And what that means is that every state was equal to every other state and
Okay.
also equal to the federal government. The federal government did not have any superiority over the states, and everybody was equal. That sounds great, but it doesn't work. And as time went on, um, we realized that was untenable, because, and really it was the founders' fear that they didn't want a strong central authority with a strong central standing army, because they had just gotten away from a monarchy,
Right.
and they were very afraid of giving the federal government that power. But when you have a separate, but it's almost like the old segregation, separate but equal, right? That creates disunity. And so they realized, after going through several small wars and skirmishes, War of 1812, the French and Indian War, all that stuff, they realized that if the federal government had no power to direct the states to do something, how could we repel a foreign invasion? The federal government would come to the states and say, please, Massachusetts, please, Virginia, mobilize your militias and defend our country. And it was perfectly capable that Pennsylvania could say, no, I'm not doing it. You can't make me.
Yeah.
And so there's no, that just doesn't work in a modern world. Um, but the true reason for that that sovereignty of the states being codified by the Bill of Rights was, of course, the Southern states' rights to what? To keep slaves, because that was the engine of their economy. They were an agrarian economy. So the original Bill of Rights, check this out, the original Bill of Rights only applied to the federal government, not the state governments. So
Right.
an individual state could suppress freedom of speech, could suppress the right to bear arms, could suppress um, Fourth Amendment rights. The federal government couldn't come in. So it was basically saying the southern states said, we'll sign this constitution, but we reserve the right to withhold power to ourselves. And of course, we know where that led. It led to the Civil War, which was, they say states' rights, but it was states' rights for slavery.
Right.
And
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 then
so
then during the Civil War, or then during the civil rights, it became states' rights to discriminate.
yes, but so after the Civil War was won, okay, and we had Reconstruction, they added three amendments, the 14th and 15th and 16th amendments, I'm sorry, the 13th, 14th. Um, so the big one was the 14th Amendment, and what that did is that the doctrine is called incorporation. It incorporated the Bill of Rights to now apply to the states. And that is what created our modern federalist system, where we have states still retain their sovereignty under the 10th Amendment,
Mhm.
but the superior um, uh, authority rests now in the federal government. So there are still vast parts of law where the feds cannot order the states to do whatever they want because the states have this serenity. Um, and that actually brings us to a lot of the turmoil that's happening today. And like you said, it after Reconstruction, and they said, okay, the slaves are freed. Um, what did the states do? They used their powers to say, okay, that's fine, great. But we're going to institute Jim Crow laws under our own police powers, and we're going to find other ways to discriminate. Um, and it took 100 years of court cases to finally evolve our way out of that. And then we get to 1954, Brown v. Board, which is where the whole segregation was thrown out the window, and there was no more separate but equal, um, which was Jim Crow, and it ushered in the modern times, but it never really solved a lot of the problems. It just kind of rolled along.
Right. Right. I mean, well, it seems like one generation's solutions are the next generation's problems. Now, just to kind of backtrack a little bit, because I'm interested in seeing the development of the perceptions of that federal system between, the War of 1812 and the Civil War. So, right off the bat, like when they were writing the Federalist Papers, was there an evolving perception of what the federal government could be? Um, or was it something that was developed later by just over time? Or was there ever I guess to phrase it, did the founding fathers, did they have perceptions of how they would like to that federal government to be developed after the French and Indian Wars?
Well, first, a lot of people throw around the Federalist Papers. It's important to understand that they carry no weight of law. What the Federalist Papers was pre-revolution. They were the era's Twitter. That's
Okay.
exactly it was
That's a good way to look at it. All right, all right.
yeah. So it was basically a public debate, and the founders, of course, agreed and disagreed, and they hashed out these concepts of how we're going to put together this nation, and they did it in public through these published essays or Twitter posts, basically. And sometimes they put their name to it, and sometimes they wouldn't, if they wanted to float an idea that maybe was radical.
Mhm.
um, but that's where how the ideas bounce back and forth, and some public clashing went on, and it also informed the citizens as to what's going on. And don't forget, the founders at the time were considered terrorist thugs, and there was still a lot of loyalty to the to King George. So
Oh, yeah.
that's another reason why they didn't put their names a lot. But um, yeah, that's when they hashed out this whole system of like, how far can we go to put together a nation where we can guarantee that it won't devolve into some sort of monarchy or other authoritarian system. They wanted to preserve liberty, but then again, they had these other questions of, well, if nobody's in charge, who's in charge? Um, we can't all just be separate but somehow unified. That also doesn't work. So they tested all these concepts. um, and the overarching concern at that time, which drove all of the debate, including the Second Amendment, was this idea that they were so afraid of the country turning into a monarchy. They were so afraid of investing power in the executive branch, the presidency, because they were afraid that it would, what is it, the saying that ultimate power corrupts ultimately. And so they originally held back a lot of these powers. And then as time went on, you get to see, like, it's like law. Okay, a law says under these facts these things are true, and
Mhm.
then you have these court cases that come along and say, well, what if this happens? What if the facts are this? What if the facts are that? And the court has to answer those individual questions. It's the same thing with nation building. Um, Obviously, the founders couldn't uh, foresee everything. So as we went along through early America, we got to see where this Confederate, it was called compact theory, where the states are separate but equal. That wasn't going to work. Especially to repel foreign invasion. And so they gradually started getting more and more comfortable putting power in a federal system. At least part of the country was. The other part, of course, was the South, who said, no, 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 we're good. We're good as separate but equal, because we know that eventually we're going to lose our slavery rights. And so they didn't want that. But after they were defeated, it kind of rolled on a new federalist system. So that was the first constitutional crisis where every the foundations of the country's legal system and its building blocks were seriously questioned.